Okay, the mic probably was not working, so we'll get started again. All right, hello everyone, very good evening to all of you. So I was telling you that, okay, less than 6 months are remaining for your exam now. And this is the time not just where you have to just complete your entire syllabi, but you also have to complete your revision, and not just that, you also have to complete your mock tests and practices. So I really hope that your preparation is coming along good so far. And not just that, you're also solving mocks and practice tests, and you're also, um, doing required revision as well. Now, the reason that we are here is because we have to understand one very important segment and component of your constitutional law for your CLAT prep, which is Union Judiciary. All right. And Union Judiciary is something which is covered under Part 5. Part 5 of the Indian Constitution, Part 5, Chapter 4. Right. And the term union here basically means at national level. Right. The way we have parliament at the national level under the union legislature, we have president as the head union executive at the national level. Same way union judiciary, yani at national level, the highest possible judicial authority that we have is the Supreme Court of India. And now how does that function? All about the same is covered under chapter 4, part 5, chapter 4 of the Indian Constitution, from article 124 to 147. Now, what does it say? Article 124 says that there has to be a Supreme Court of India. Supreme Court of India is the highest possible judicial authority of the country, right? Highest possible court. So if we talk about justice, Supreme Court is the highest justice providing authority in India, and it is also considered as the guardian of the constitution. Guardian of the constitution basically means, see, when the constitution was made back in 1950, yeah, so at that time, there were a lot of things that were probably not clear to the constitution makers, and also a lot of things which were not very clearly mentioned in the constitution, which can have multiple meanings. So now the parliament does not has the authority to give meaning or give interpretation to those provisions, neither does the president. The power of giving interpretation, giving meaning of those provisions that are given under the constitution is with the Supreme Court of India, and all the rights, all the duties provided under the Constitution of India has to be protected by the Supreme Court, right? So it is the duty of the Supreme Court to guard the Constitution. Why? Because Constitution is the highest possible law that we have, and it is the duty of the Supreme Court to interpret the law, to explain the meaning, to give meaning of what all provisions are there in the Constitution. Okay. Now let us understand it a little bit better. So originally, when the Constitution was made, okay, it was said that the Constitution said that there are going to be in total 8 judges, 7 judges, and 1 Chief Justice of India. Chief Justice of India is the highest possible judge, right? We use the word justice for High Court and Supreme Court judges. So, highest possible judge, the senior most judge of the Supreme Court also is is the Chief Justice of India. Now, originally there was this provision of 7+1 judges, right? Then, due to a lot of amendments that were done, right? There was last we had 33+1 judges. Very recently, we've had this amendment, and now we have 37+1 judges. 4 new judges have been added to 4 new more positions for Supreme Court judges have been added, right? So yes, that is there. Now, who can be a Supreme Court judge? Very important, very interesting to understand. Who can be a judge? First of all, he or she should be a citizen of India. First things first. No non-Indian can become a Supreme Court judge. He has to be an Indian citizen. Secondly, he has to be at least a High Court judge for 5 years or an advocate of High Court for at least 10 years. Then he can become a Supreme Court judge. Okay. Or if the president thinks that someone is a distinguished jurist, someone who has eminent knowledge of law can also become a Supreme Court judge, right? So three requisites are here: Indian citizen, either High Court judge for 5 years, either High Court advocate in High Court for 10 years, or maybe a distinguished jurist recognized by the president. However, this position so far has never been, this power has never been used by the president. He has never appointed any eminent jurist as the Supreme Court judge. But these two, primarily, yes, they are being used. Okay, so now what is the process otherwise for appointment? Let's understand. So, Constitution says that the president is going to have the power to appoint the Supreme Court judges. Simple. President can appoint. Now, president is part of the executive. So, if executive is going to appoint the judicial service members, in that case, we have something called independence of judiciary in India under Article 50, right? So, if president is going to directly appoint Supreme Court judges, then maybe it is going to be against spirit of independence of judiciary. That is why we have something called a collegium system, right? Collegium system that is responsible for appointment of judges in High Court and Supreme Court. Now, what is this collegium system? Let's just quickly understand. Now, in this collegium system, there is a group of judges that is responsible to appoint further new judges, right? So now for Supreme Court of India, Chief Justice of India and the four other senior most judges, they form a collegium. So if you ever get a question about the collegium, what does the collegium means? Collegium means CJI plus four senior most judges of the Supreme Court, right? They together form a collegium and they decide who is going to become, who can become a Supreme Court judge, right? Now it can be someone they want to elevate from High Court, right? It can be an advocate who is practicing in Supreme Court, they want to make him a Supreme Court judge, that can also be possible. They are going to decide and they will nominate those names, or they will just recommend those names to the president, and the president just has to announce and has also has to ensure that whenever those people are appointed as Supreme Court judges, they take an oath under the president. But otherwise, the real decision making lies with the collegium. So when we talk about the independence of judiciary, it is secured through collegium system. President's role is there, but it is not purely president's role that is going to define, right? It is predominantly the judiciary's role itself. Okay, all right. Now, that was about appointment. Let us just quickly understand about the removal of the judges as well, right? So now for removal of judges, there is something called an impeachment process. Now it is very similar to a process of removal that we use for president as well, right? The process used for removal of president is also known as impeachment. Process used for removal of a Supreme Court or a High Court judge is also known as impeachment. However, the process is slightly different, right? But the name is kind of similar. But we do not have to get confused between the same. Both of them means removal of president or maybe of Supreme Court judges, but the process can be slightly different. Okay, now what is this process? Let's understand this. First thing, what can be the reason for removal? Can we just remove the Supreme Court judge on anything for any reasons? No. The reasons have to be either proven misbehavior or incapacity. Simple, right? And now how does this process has to begin? To start this process, any house can start a motion. Motion basically means a proposal or a resolution that we want to remove this person from the position of a Supreme Court or a High Court judge, right? Motion. Motion has to be started by either of the houses and it has to be passed by both the houses separately. So if it is first started in Lok Sabha, then it has to be passed by Lok Sabha, then it has to go to Rajya Sabha, and then it has to be passed by Rajya Sabha as well, right? Has to be done separately and it can start in either house. Now, to pass that resolution, it needs something called a special majority. Now, it is very important. This is the core difference between removal of president and removal of Supreme Court judge, right? It is the special majority. The definition of special majority is something which is very different, okay? In this case, what does it mean? It means majority of total membership and two-third majority of members present and voting. Okay. Yeah, it means special majority means total membership and my bad. Yes, total membership of the house and two-third majority of members that are present and voting. Now, what does that mean? Let's understand. Total membership of the house. Total membership of the house. Yani ki now let's say the resolution has first started in Lok Sabha. Okay, and let's just assume this just for the sake of example. Lok Sabha has 100 people, 100 members in total. Okay, so now there is a possibility. So now it says total membership of the house, yani ki majority of the total membership, yani ki if Lok Sabha mein there are 100 people, majority, more than half. So at least 51 people from Lok Sabha should vote in affirming that they want the judge to be removed, plus two-third majority of members present and voting. Now, if there are 100 people, on the day of passing of that resolution or voting, there is a possibility that not all 100 people are available or are present. So now let's say only 50 people or let's say 60 people are present. On the day of voting, only 60 people are present out of 100. So out of those 60 people, two-third people should be should vote in affirmative. So now two-third of 60 becomes 40, right? So if in total 40 people have voted when present, right, when on the day of voting, 40 people have voted, and also simple majority of 51, right? Simple majority plus special majority. That means this this number is, it should be equal or higher than majority of total membership. This number should have been equal or higher than 51. Only then that resolution could have been passed. Now let's say on this day 90 people were present. Okay, so now by that logic 60 people have voted, right? And 51 were required from the simple majority. 60 were required from the special majority. If both these criteria are met, right? So in that case, this resolution will be passed, and this practice has to be done by both the houses. Once it is done by both the houses, then it is going to go to the president, and then the president is going to sign, and the person, the judge, will be removed. Now, so far in the history of independent India, no Supreme Court judge has ever been removed from this process. The process has started against many, yes, but has never been successful, or maybe during the process only the judge, they resigned from their position. That has also happened. Okay. So yes, okay, now understanding a little bit more about them. So salaries. Now we say this thing that Supreme Court judges are independent. There is independence of judiciary in India, right? So there are independence of judiciary. So by that logic, they should have some different source of salaries maybe because they are independent, but no. They get their salaries from the Consolidated Fund of India. Now, what is the Consolidated Fund of India? Consolidated Fund is like the savings account of the government, right? So, they get salary from the government itself. So, in a way, judges are also government employees. Secondly, acting CJ. There is a provision of acting CJ. Now, let's say the Chief Justice of India is on a medical leave, or maybe is traveling somewhere, is out of office due to any reason. So, during that time, will we not have any Chief Justice? No. That is not true. In that case, there's something called an acting Chief Justice. Acting Chief Justice, yani ki he's acting to be Chief Justice. He's not actually Chief Justice. He's Chief Justice till the time the real Chief Justice comes back. Right? So now, whosoever is, yeah, whosoever is appointed by the president to become the acting CJ becomes the acting CJ, right? Then we have this provision of ad hoc judges. Now, let's say the Supreme Court of India is overworked, right? They have a lot of, they're overburdened, they have a lot of cases that are pending and they cannot increase the number of judges. So in that case, what they can do is that on temporary basis, let's say for 2 months or 5 months or 6 months, they can ask certain High Court judges to assume the office of a Supreme Court judge for, let's say, 4 months or 5 months or 6 months and redress the duties of a Supreme Court judge. And once the workload is relieved on the Supreme Court of India, these judges, these high court judges who were assuming the role of a Supreme Court judge can go back to their high courts and can continue their duties. That is called ad hoc judges. On temporary basis, they're there, right? They are not originally a Supreme Court judge, they're high court judges only, but just for the time being, right, to help the Supreme Court maybe, right, they have assumed the duties of the Supreme Court judge and they are redressing those duties. Then the retired judges, retired Supreme Court judges can be requested to sit and act as judges because see we are an extremely populated country, right? And we have a lot of, sorry, my bad. We are extremely populated country. We have a lot of pendency of cases. Supreme Court is overworked, it's overburdened, and the number of judges are very less. Out of which, if Supreme Court judges they get retired, retirement age for the Supreme Court judges is 65 years, right? So if they get retired, right, and there is scarcity of judges now again in Supreme Court, then we can ask, the president can ask, or the president can approve upon the request of the Supreme Court to retain a few retired judges to deliver some duties on temporary basis. Okay, that is also something which is possible. Now, it is said that the Supreme Court of India is a court of record. Court of record means that the judgments are going to have an evidentiary value. So if there is this judgment, let's say there is this case A versus B has happened in which a certain judgment has been given. Now the same judgment can be used for future similar circumstances as well, right? And it is going to be used as a established principle for all the lower courts, for all the high courts and all the subordinate courts, it's going to be used that way, right? Secondly, Supreme Court has the power to punish the court, punish for its contempt, right? Contempt basically means disrespecting the court or not obeying the court, right? So if there is any situation where the court is contempted, the person can be punished, okay? All right, now seat of the court, the seat of the court is going to be New Delhi. Of course, we know this thing. Supreme Court is only one and that is in New Delhi. There are no multiple Supreme Courts. We have multiple High Courts for sure, but there is only one Supreme Court and that is going to be, the seat of the Supreme Court is going to be in New Delhi and that's the permanent seat. The seat can be changed, it can go to other places, but this provision has never been used. But the constitution, it allows it. If the president wants, it can do it, but it has never been done so far. Okay. And lastly, few powers that are there with the all right. So there are something called jurisdictions. right? Jurisdictions basically means power of the Supreme Court to hear a certain cases. Now, what all those different jurisdictions are? First is original jurisdiction. Original jurisdiction means the court which has the power to hear the case for the very first time. If any dispute happens, it has to go to a court, right? The court that is going to hear the dispute for the very first time, the very first hearing of that entire dispute, anywhere in the court, in any sort of court, right? That court is going to have original jurisdiction. So now for Supreme Court, most of the judgment, most of the cases do not have original jurisdiction. I mean, Supreme Court does not have original jurisdiction on most of the cases, right? The hierarchy is that you have to first go to the lower court, then you have to go to the high court, and then you have to go to the Supreme Court, right? And we have to follow this hierarchy. We cannot directly go to the Supreme Court unless the dispute is between union and states, between states and states, right? If the dispute is between government of India and government of some other state, or maybe state of Haryana and state of Delhi, so in that case, the Supreme Court has the power to hear that case for the very first time. Second is appellate jurisdiction. Appellate jurisdiction, civil, criminal, and constitutional. Appellate basically means appeal. Appeal usually arises from high court judgments. So if any party is not satisfied with the judgment of the high court, right? In any civil, criminal, or constitutional matter, then they can also approach the Supreme Court in that cases. And Supreme Court also have something called writs. Very important, extremely important. I think probably one of the most important topics for your exam is going to be writs, right? So Supreme Court under Article 32 of the Indian Constitution has power to issue 5 writs. First is habeas corpus. If any person has been illegally detained, then that person or his family members, any relatives, friends can file the writ of habeas corpus, right? Habeas corpus, where the court orders the public authorities to present that person to the court, right? You have to present the body. Second is mandamus. Mandamus means weak command, where the court orders the public office or the public officials to perform their legal duties. Third is certiorari. Certiorari means to certify, right? To certify. Here in this, the Supreme Court has the power to quash, to cancel those judgments given by the lower courts, which those lower courts did not have the power to give judgments on. Now, let's say a dispute has happened in North Delhi, right? So the district court of North Delhi will have the power on it. But let's say the dispute was filed in the district court of South Delhi, and that district court has given a judgment on the same. So in that case, that court did not have the power to do it, right? So the higher court or the Supreme Court can quash, can cancel that order given by the wrong court. Prohibition. Prohibition basically means to stop the public authority to do something. And lastly, quo warranto. Quo warranto is more like a question. That by what authority? It is by basically you are challenging a person's right to hold a public office. Right? Now let's say a person is holding a government position, a government office, right? He's a government officer, but he does not meet the eligibility criteria. In that case, you can file the writ in the Supreme Court challenging his appointment, right? And the Supreme Court in that case can ask that by what authority, sir, are you holding this office, right? That is the writ of quo warranto. So yes, that was something I have to share with you about the Union Judiciary, right? Let me see if there are any quick questions. Yes, it is important topic. Any further, any doubts, any questions if you have, you can quickly let me know. If there are no further questions, then I'll wrap the class. Okay, I checked there are no further questions. So if there are no further questions, everyone, then I'll wrap the session. Thank you so much, everyone, for joining. I hope you found it useful and I hope you found it, insightful and you're going to use this in your preparation as well. All right. Thank you so much, everyone, and I'll see you again in the next live video. Bye.